Hello friends, welcome to Abhinav Goswami Law classes. So friends, in this video we are going to discuss from section 45 up till section 51 of Indian Evidence Act. Why I am doing all these sections together friend? Because they all fall under the same heading. They are of same category, that is when opinions of third persons become relevant. Okay, so what is the rule friends? That opinion of third persons are not related to the suit. It is the parties to the suit whose opinion must matter in a case. But these sections from section 45 to section 51 provides for certain scenarios in which opinions of third persons also become relevant for deciding a particular case. Okay friends, so I will try my best to conclude this lecture within 30 minutes. So friends, please open your Bear Act, open section 45, a very important provision. So friends, section 45, as far as section 45 is concerned, it reads about opinion of experts. So what is meant by experts? Who are actually the people you will call experts? For understanding that, we need to read section 45. Section 45 reads opinion of experts. Okay, when the court has to form an opinion upon a point of foreign law or of science or art or as to identity of handwriting or finger impression, the opinion upon that point of person especially skilled in such foreign law, science or art, or in questions as to identity of handwriting or finger impression are relevant facts. So friends, what did you learn from section 45? The first thing that you must learn from section 45 is that experts are those persons who are especially skilled, not only skilled, especially skilled in that particular area of which they are experts. Okay, this is what is meant by definition, what is meant by experts. Now we will look at the requirements of section 45. The first thing that you must understand is that section 45 is not talking of all category of experts. It is specifying four areas experts in which opinion of experts in that areas only will be relevant under section 45. What are those four areas friends? Foreign law, science, art, handwriting or finger impressions. So handwriting and finger impression, we will make them into the same category. And what are the other three categories? Foreign law, science and art. So you may be thinking that it is quite restrictive, but it is not friends. Why? Because science is a very broad term. It includes a lot of things in it. Same goes with art. Art is also a broad, very broad word. So it will include a lot of people, a lot of experts in it. So what you need to remember is that as far as the categorization of experts are concerned, they have divided into four broad categories of foreign law, science, art, and identity of handwriting or finger impression. But this does not mean that the section 45 is very restrictive. Okay, what is the second thing? Now, once you find an expert on any of these 4 points, then the opinion of such experts, who were experts friends? People who are especially skilled. So when I say experts, you must presume that I am talking of people who are especially skilled in these areas: foreign law, science, art, or question of identity or handwriting or finger impression. So these opinions of these experts become relevant in regard to these four categories, these four areas. Okay, so what I am trying to say under section 45, what you need to remember is, first thing that you need to clear about is that opinions of experts are being made relevant under section 45. This is the first thing that you need to understand. The second thing is that not all opinions, not everything whatever they say is becoming relevant. No, their opinions only in regard to the category of which they are expert, in which they are especially skilled. For example, if the person is an expert of foreign law, then his opinion in regard to foreign law. Same goes with science, his opinion in regard to science. Same goes with art, his opinion regard to arts. And handwriting or finger impression, same goes with that also. So opinion of experts, this is the first requirement. Second, the opinion should be in regard to any of this or any of these four broad areas. Okay, and who are experts, friends? People who are especially skilled. Okay, so this is what section 45 is. So experts are third persons. Their opinions are becoming relevant because they are especially skilled in any of these area, which can actually help the court of law to decide a particular matter. That is why their opinions are becoming relevant, even though they are third parties to the suit. Okay, friends. So we are going to look at only one illustration because the illustrations are quite easy. They will not cause much distress to you. Okay, friends. The first illustration is, the question is whether the death of A was caused by poison. So the simple question is whether A died because of poison or not. Okay. The opinion of experts as to the symptoms produced by the poison by which A is supposed to have died are relevant. So the experts, their opinion. So what category of expert, friends? The experts falling in the category of science, right? Science. So the expert opinion of the experts who are expert in this area of poison and chemicals, their opinion as to what are the symptoms of this poison are relevant, because on the basis of that evidence of these people, of these experts, the court can actually see whether this person who has died had the same symptoms or not. Okay, so this is the manner in which experts opinion is becoming relevant in this illustration. So this is your homework that you are going to look at B, C, in the next illustration of B and C by yourself. Okay, friends. Now come to next section, section 45A, opinion of examiner of electronic evidence. So as far as section 45A is concerned, it is specifically about electronic evidence. Okay, what was section 45 about? It was evidences regarding science, arts, foreign law, and handwriting and what was the other category of experts, friends? Tell me. Handwriting and finger impressions expert. Okay, so these were the four categories, but under section 45A we are only specifically talking of electronic evidence. Section 45A reads, when in a proceeding the court has to form an opinion on any matter relating to any information transmitted or stored in any computer resource or any other electronic or digital form, the opinion of the examiner of the electronic evidence referred to in section 79A of the IT Act is a relevant fact. Okay, so here we are not using the term expert. Here we are using the term examiner of electronic evidence. And why are we doing so, friends? Because the IT Act uses the same term. So as not to cause any confusion, so that no, if the Indian Evidence Act uses the term expert and IT Act uses the term examiner of electronic evidence, so there may be confusions whether they are the same persons or not. So to remove all those difficulties, the term examiner of electronic evidence is used. So when will these opinions of examiner of electronic evidence will become relevant? When the court has to form opinion as regards any information that is stored in any computer or other digital technology, or when any particular information is transmitted through such computer or any such electronic technology. So in such cases, if the court has to form the opinion, if the court has to test whether the information that is stored is authentic or not, whether the information that was transmitted was authentic or not, the court can take the help of examiner of electronic evidence. Okay, so what is the explanation? For the purposes of this section, examiner of electronic evidence shall be an expert. Okay, so what I was talking, that though the terminology is different, but you must always keep in your mind, it is just a way to refer an expert who is an expert in electronic records. Okay, friends. Now come to section 46, facts bearing upon opinions of experts. Section 46 is very important, because from section 45 to 45A we were talking of category of experts. Now we are talking of all categories of opinion which have a relation to the opinions of experts. Very interesting section, please pay your full attention. Facts not otherwise relevant are relevant if they support or are inconsistent with the opinion of experts. When such opinions are relevant, So this section 46 is very broad. It is simply saying that whatever facts are either supporting the opinions of experts under section 45 and 45A, or not supporting or going against the same opinions, then those facts are also will also become relevant. So all the facts before the court of law which are supporting the case of the experts or going against it, they will also become relevant. Why, friends? Because the opinion of the experts, though it is a relevant fact, but it is not a conclusive proof. Okay, it can help the case of one of the parties, but the determination cannot be on the sole basis of experts opinion. So that is the reason that section 46 is there, because we are taking the opinion of experts. We should allow equal opportunity to the other party to bring facts which go against the opinion of this experts, or to the same party that to bring evidence which support the evidence of experts so as to win the case. So both the parties are free after an opinion has been given by an expert, either to bring evidence or bring facts which are supporting the opinion of the expert or going against it. Okay, what will be the example of this? Illustration A. The question is whether A was poisoned by a certain poison. So the same question, whether A was poisoned by a certain poison. Okay, the fact that other persons who were poisoned by the same that poison exhibited certain symptoms which experts affirm or deny to the symptoms of that poison is relevant. So very interesting illustration, because it is covering both the categories of facts which are either supporting or going against it. The illustration is saying the main fact and issue is that that this person A has died. Now the question is arising whether he was poisoned by a certain category of poison, for example poison X. So experts come, okay, they provide that this poison X has these symptoms. Okay, so these symptoms which the experts have provided, which the experts have written down, they may match the symptoms of this person or they may not. So if there are not only A, but if there are other persons also, for example B, C and D, they were also poisoned by the same category of poison. If the symptoms of those persons are not same as of A, which are told by this person, these experts, that these are the symptoms of this poison, then what these evidence is showing, that it is going against expert opinion, because the symptoms of B, C, D are not same as of symptoms that were told by experts regarding this poison X. But if the symptoms of B, C, D also are the same symptoms which are told by experts as the symptoms of this poison, then it is supporting expert evidence. Okay, so this illustration can be used either way. So all the facts which either support or go against experts opinion, they also become relevant under section 46. Now come to section 47, opinions as to handwriting when relevant. Okay, so we under section 45 we have already discussed that experts are allowed to give evidence as regards handwriting and finger impression. But the question arises, when will the court ask for evidence? When will the court ask for opinion of experts in regard to handwriting? When will be that situation? When the court has to form an opinion as to the person by whom any document was written or signed. The opinion of any person acquainted with the handwriting of the person by whom it is supposed to be written or signed, that it was or was not written or signed by that person, is a relevant fact. Friends, section 47 is going to bring a bit of complication for you. I'm going to clarify that for you. So friends, the first thing that section 47 is saying, that the court can only ask for opinion of third parties in regard to a particular handwriting only when the question arises whether any document was written by or written or signed by a particular person or not. Only when the court has to form an opinion in regard to whether a particular document was written or signed by a particular party or not, only in such cases the court can rely on the opinions of third parties. So these third parties can be divided into two categories, friends. These third parties can either be experts, as mentioned under section 45. Who are experts, friend? How will they decide the authenticity of handwriting? They will make this person to write something and compare that handwriting with the handwriting of that document. This is, and they will match each and everything. They are skilled in that. This is what the expert's opinion on handwriting as per section 45. But the other category of third person's opinion are those people, they are not experts in handwriting. They are those people who are generally acquainted with the handwriting of a particular person. For example, my friends are acquainted with my handwriting. So their evidence, because they can actually recognize that this is written by Abhinav or not. So their evidence, their opinion is becoming relevant under section 47. And the opinions of the experts in regard to handwriting was becoming relevant under section 45. So you need to make a distinction between these two, because opinions of both are the opinions of third parties. In this case, my friend is also third party, expert is also third party, but expert opinion will go under section 45, and my friend's opinion, other people who are acquainted with my handwriting, their opinion will fall under section 47. Now explanation. A person is said to be acquainted with the handwriting of another person when he has seen that person write at any point of time, or when he has received documents purporting to be written by that person in answer to documents written by himself or under his authority or addressed to that person, or when in the ordinary course of business documents purporting to be written by that person have been habitually submitted to him. So friends, when section 47 said that we will take the opinion of people who are generally acquainted with the handwriting of a particular person, but how will you determine as to who is generally acquainted with the handwriting of a particular person or not? What is the criteria? So criteria is provided by this explanation. It says that if at any point of time a particular person has seen this person write, then he will fall within this category of that he is acquainted with that handwriting of that person. Or if he is habitually receiving documents from this person, letters and other, there is no conversation going on between them in terms of letters and everything, so obviously he will be acquainted with the handwritings of that person. Or if in the ordinary course of business between them, that they exchange letters or things between them which are handwritten, that will make that person fall within this category of generally acquainted with the handwriting of that person. Okay, so this explanation is providing for 3 or 4 criteria when will a particular person will said to be acquainted with the handwriting of a particular person. Okay, you can look at the illustration, it is very simple. Now come to section 47A, opinion as to digital signature when relevant. When the court has to form an opinion as to electronic signature of any document, the opinion of the certifying authority which has issued the signature certificate is a relevant fact. So friends, when we did section 47, I distinguished between section 45 and section 47. So when we are doing section 47A, we need to do the same thing. We have to distinguish it from section 45A, because section 45A was talking of opinion of examiner of electronic records, examiner of electronic evidence in regard to the information which was stored in a particular computer or any other digital technology, or which was transmitted through that computer or any other digital technology. But when we are coming to section 47A, it is very restrictive. It is very restrictive. It is only talking of digital signatures. What are those? So you must have heard, no, IT, if you read IT Act, it also has a definition of digital signature. So there is a manner, or this digital signature is not like any other signature, just you can do that. No, these digital signatures are actually issued by a certifying authority established under the IT Act. So as far as the authenticity of this digital signature are concerned, they cannot be given by any expert, as was the case under section 45A. They can only be given by the certifying authority which actually issued that digital signature or electronic signature. Okay, so section 47A is very specific about digital signature, and only the certifying authority can provide evidence in regard that. But when we talked of section 45A, it was quite broad. It was talking about all categories of information in a computer or other digital technology, and experts' opinion were allowed in that category. Okay, friends. Now come to section 48, opinions as to existence of right or custom when relevant. Okay, When the court has to form an opinion as to the existence of any general custom or right, the opinions as to the existence of such custom or right of persons who would be likely to know of its existence if it existed are relevant. So friends, as far as you know, what are customs? What are customs? Customs and general rights are those things which are nowhere written. They are the part of traditions. Okay, but how will you prove a particular custom? How will you know that? Because it is not written anywhere. It is only by way to show that it is being followed for a long time, and people are, or when will people follow that custom? When they will be aware of it. So in order to, if the court is confused whether a particular custom exists or not, so in order to know that, it can ask for the opinion of third parties. And who will be those third parties? Third parties will be those parties who must be aware of that custom for whatever reason. Either these third party belong to the same community or to the same family or dealing in the same category of business, whatever reason. But because of the proximity of that person, that person must be aware of that custom or right if it ever existed. So in such cases, the opinion of such a person becomes relevant under section 48. Now read explanation. The explanation, the expression general custom or right includes custom or rights common to any considerable class of persons. So this, when we use this term general custom or right, we are not restricting it to a particular community or to a particular family. It can extend to a large area, or it can be restricted to a single family. That we know. We know the definition of custom. It can be a broad custom, it can be a very specific custom. But what is that you need to understand as far as section 48 is concerned, that court can ask for the opinion of persons who must be, because of their proximity with that custom, must be acquainted with that custom if it ever existed. Okay, now come to section 49, opinion as to usages, tenets, etc. when relevant. When the court has to form an opinion as to the usages and tenets of any body of men or family, the constitution and government of any religious or charitable foundation, the meaning of words or terms used in particular districts or by particular classes of people, the opinion of persons having special means of knowledge thereon are relevant facts. So friends, section 49 you can say is in a way an extension of section 48, because section 48, what it is making, opinion of people in regard to customs. But what section 49 is doing, it is making opinion of people who must be having special knowledge because of their proximity with this thing. Opinion in regard to what? Three category of things. First category of things, yes, usages and tenets of any body of men or family. Friends, what are usages? Usage is a prior stage of custom. It is a particular activity which has not yet attained the stage of being a custom, but it is just a usage. Okay, and same goes with tenets. Tenets is like this, there are some tenets of religion. You can associate it with traditions. Okay, so if the court is confused whether a particular usage exists, whether a particular tenet exists in a particular family or in a particular body of men, body of men is means that a particular organization, then the court can ask for the opinion of third parties. And who will be those third parties? Those will be those people who must have, because of their position, special means of knowledge. And how will they have this special means of knowledge? Either they may belong to the same family or same body of men, or they must be proximate to it. Okay, so all these circumstances make them have the special means of knowledge in regard to that. So in such cases, the opinion of such person becomes relevant. Same goes with the second category, the constitution and government of any religious or charitable foundation. So what is the constitution of a particular religious or charitable foundation and how it is governed? So it may not be written anywhere. So if the court has to form opinion in regards to these matters, then it can take opinion of third parties who have special means of knowledge. And how will they have a special means of knowledge? Either they belong to the same charitable foundation, maybe, or they may be belong to the same religion, same religious foundation. So this position, their position gives them the special right to have a special means of knowledge. Finally, the third category is the means of words or terms used in particular districts or by particular classes of people. This is very specific. It says that, there is a difference in the way we talk. the terminologies that we use in everyday language. So particular area of your country may be referring to the same thing by very different words, which may be restricted to that area only. So if and the code may not be relevant or of all these linguistic things, no, right? So if there is a confusion before the court of law and the court has to form opinion whether what is meant by this word, what is meant by this thing which is written in a contract, okay, so in order to reach a particular conclusion, the court can take help of the opinion of third parties. Who will be those third parties? People who have special means of knowledge. And who will be those people in this case? People who belong to this particular class of people, people who belong to this particular district or this area. Okay. So as far as section 49 is concerned, it is also making opinions of third parties relevant in regards to these three categories that we discussed. But it is very necessary that the persons whose opinion is being taken, they must have special means of knowledge because of their position in relation to any of these three circumstances. Okay, friends. Now come to section 50. Opinions on relationship and relationship. When the court has to form an opinion as to the relationship of one person to another, the opinion expressed by conduct as to the existence of such relationship of any person who as a member of the family or otherwise has special means of knowledge on the subject is a relevant fact. So friends, as far as section 50 is concerned, it is very interesting section. Why it is very interesting section? Friends, that in this case, the opinion is not being expressed by words of mouth. It is being expressed by conduct of the parties. This is very important because words of mouth can be manipulated, especially in such scenarios. Because, for example, if there is a case going and there is a dispute whether this person is a son of this person A, whether B is son of A or not. So when the dispute has already arose, so all the family members become conscious of it, right? They may start behaving in a manner or they may depose wrongly so as to serve the interest of their whatever to whomever they are more close to, right? So if for this reason the opinion which is being made relevant of people here is not their words, it is what they have, the way they have been conducting themselves before the dispute actually arose. So what you need to learn about section 50 is that this can be relied in those cases when the question before the court of law is whether a particular relationship exists between the two people or not. It can be of whatever category of relationship: husband, wife, father, son, mother, son, father, daughter, uncle, niece, grandfather, son, whatever be the category of relation. If existence of a particular relationship between two persons is in dispute and the court has to reach the opinion in regard to that, the court can take the help of the opinion of third parties. Okay, so who will be the third parties? Who have a special means of knowledge of that relationship. And how will they have this special means of knowledge regarding that relationship? They may be either family members. Obviously, if they are family members, they must be knowing what is the relationship between these two people. Or they may be neighbors. Okay, they may be anyone who are close to these people, who because of their position have a special means of knowledge. So their opinion not expressed by their mouth but expressed by their conduct as to how they treat this person. Are they treating this B as son of A or not? Have they been treating this person C as wife of A or not? So their conduct, the way they what was the thing they used to call this person. So if there is a dispute whether B is the wife of A or not, or whether B is the son of A or not, so how was the other family members treating this B? How were they calling him? How were they treating with him? So if they were treating him like a son, or they were calling him the son of A, so this is something that is opinion by conduct, which can be taken into consideration by the court of law so as to prove the relationship between these two parties. But there is a very important proviso in this case: provided that such opinion shall not be sufficient to prove a marriage in proceedings under Indian Divorce Act or in prosecutions under section 494, 495, 497, 498 of IPC. So friends, this is very important, that these opinions by conduct of these people who have a special means of knowledge regarding relationship between two parties will not be sufficient in regard to if the question is whether two people are husband or wife or not in divorce proceeding under Divorce Act or under 495, 495, 498, 497. So under all these sections or under Divorce Act, the opinions of these people, the family members, that these A and B are husband and wife, will not be sufficient. Opinions can be taken. This proviso is not saying that the court is prohibited from taking opinions of these third persons in cases of marriage. No, no, no. Opinions can be taken, but they will not by themselves be sufficient to decide that matter. This is very important, because when we were reading Hindu Marriage Act, I told you that there are certain requirements which you need to do before you enter into a valid marriage. So you will have to show each and everything, that not only the opinions of the family members that yes, they are husband and wife, will not be sufficient to prove their marriage. They will have to show that this ceremony was done, that this person was not of unsound mind, that consent was taken. So all the requirements mentioned under section 5 have to be complied with, right? So only then it will be held to be a valid marriage. Same goes with Divorce Act and all these sections of IPC that are mentioned here. So the opinions of the family, opinions of these people who have a special means of knowledge, will not be sufficient to prove marriage. This is what proviso is providing. But as regards other relations, it is more or less good. Illustration, it is for you to go through. Okay, very easy illustration. They are not very hard. That is why I'm not doing them, because I will just be wasting the time. Now come to our final section, the last section, section 51, grounds of opinion when relevant. Very, very important section, friends. Whenever the opinion of any living person is relevant, the grounds on which such opinion is based are also relevant. So friends, from section 45 up till section 50, what we are doing? We are making the opinions of certain third parties to be relevant, for the reason they are expert, for the reason they are specially placed, for the reason they have special knowledge, right? For whatever reason, we are making the opinions of third parties relevant, right? But what section 51 is saying, that not only the opinion, not only the final opinion of that expert of that or that person who has special knowledge, but also the grounds on the basis of which that opinion is formed. For so if the expert is saying that, if the expert is saying that ABC is right, then not only this fact that ABC is right, but also how did the expert reach this conclusion? What were the factors which are taken into consideration by this expert? They will also become relevant. So that not only the final opinion, but the entire process of formation of opinion, everything become relevant under section 51. What are they called? Grounds of opinion. Same goes with people who are specially placed. Same goes with people who are have special knowledge. So not only the final opinion, but their grounds also become relevant under section 51. Okay, friends. Finally, what is the reason for this, friend? So that these experts, these people who have special knowledge or who are specially placed, they do not misuse their position of being an expert or specially placed. That is the reason that grounds are also taken into consideration. So if you are giving a particular opinion, you have to justify, you have to show the grounds. Why did you reach this conclusion? Why are you giving this opinion? On what basis you are giving this opinion? So section 51 is a protection against misuse. So again, the illustration, it is for you to do. So finally, friends, we are done with our lecture for today. Section 45 to section 51, a very important provision of law. So friends, I hope the lecture was very helpful for you. So friends, if you want to appreciate my efforts, please subscribe to my YouTube channel. And if you want to connect with me on Telegram, the invitation link to my Telegram group is pasted in the description to the video. Until then, friends, be safe, be happy. I'll see you very soon. Bye-bye.